have to push the button to unmute myself. Okay. All right. So this meeting is about Powley v. Bisignano, published on March 18th. So I came into the office the following day and saw that they had published this, and I immediately ran into Lawrence's office to tell him step five case, published decision from the Ninth Circuit, big step five case. Uh, what would what was your first impression hearing that and opening up the document to read it? What was your first impression, Lawrence?
Well, my first impression was that I don't trust the I don't trust ALJs. I don't trust the courts. I don't trust anybody any further than I can spit them, and I can't think of them in my mouth. So I was not happy about it. It's always with great trepidation that I start the process of perusing a Ninth Circuit published opinion.
Okay.
Great trepidation.
Yeah. So we open up the document together and we're looking at that first page, uh, and we see that the opinion was written by Judge Callahan. What were your thoughts at that point?
We're about to get wasted. She's gonna destroy us. Judge Callahan is very conservative. Uh, she and this goes to both sides of the political aisle. She's an apologist for the for agency discretion, and so I was not. My heart sank when I saw that Judge Callahan. She wrote the decision in Terry v. Saul, where she said everybody assumes that light or medium work means 6 hours in an 8 hours day of standing and walking, which is just nonsense. So she erects this presumption, which wasn't resolved until we get to Conway. So I was not happy about it.
And so we start reading this opinion and the occupations that were identified. The vocational expert testified to eyeglass assembler, which is final assembler in the DOT, representing 39,425 jobs. Jewelry preparer, representing 24,700 jobs, and fishing reel assembler, with 14,700 jobs in the national economy. And as we get to that point in the decision, what were your thoughts on those occupations? Did anything jump out to you?
There are three kinds of lies in this world. There are lies, there are damn lies, and then there are statistics. And those three occupations, to claim that those three occupations represent circa 80,000 jobs is a statistical lie. And if I didn't see who counsel of record was when I started reading this decision, which is Kevin Kerr's firm and Allison in one of Kevin's partners, I would have been horrified. But I know that they did not let that set, so I was anxious to read on.
Right. And Kevin Kerr's firm actually did successfully rebut eyeglass assembler in Erickson v. Saul.
Which is
So
an unpublished opinion.
right, right. So we had some glimmer of hope on that basis. But as we read on, we see that Kevin Kerr's firm pub or submitted rebuttal evidence from Skiltran and from the U.S. Census, basically showing less than 50 jobs across all three occupations. And the court found that they were substantial and probative, and that the ALJ had to address it. Now, do you have any thoughts on the court's analysis there, and particularly what as representatives, what we have to do at that stage.
Somebody's had some feedback going on. If you could just mute your mics, please. Um, the uh, the the first two the second two occupations, jewelry preparer and fishing reel assembler, are straight up um, Job Browser Pro numbers, and the vocational expert claimed to be using Job Browser Pro, and final assembler also is rebuttable within Job Browser Pro. But Allison and Kevin's approach in this case was not just uh, to be a one trick pony. We can't do that. We have to keep going and leave no stone unturned. These people are going to they're going to continue to make things up as they go along. They're going to continue to uh, uh, lie and prevaricate. And so I was really happy to see that they were using county business patterns. It is paragraph 2 in 404-1566D. And so it is imperative that we always use that that information. And I was really happy that Kevin did and Allison did present that evidence. Let me go ahead and take control and share the screen, because this is really okay. Eric, you didn't put me back on a control status, so I need
you have permission now. You should be able to share.
All right. So uh, let's see, share. I got to click on share. Here we go. All right. So this is just a straight up Job Browser Pro report, and you can see that it's Fishing Reel Assembler, and Job Browser Pro in this iteration says there's 22 jobs. And I actually had a conversation with an attorney the other day. This area in here in the middle where it says NAICS codes in 33900, other miscellaneous manufacturing, that is a North American industry classification code. There are, within production workers all other, this is 519199. There are 5,477 jobs. We're going to actually look at that data in a second. But there's only 22 of them that are reasonably attributed under the equal distribution method to production workers all other. There are only circa 240,000 production workers all other and almost 1,600 DOT codes. And to tell me that 3 sedentary DOT codes represent 80,000 jobs is preposterous. The reason any occupational group that ends in a 9 is an all other occupational group. It means there's not enough of them in any group of similar occupations to warrant their own classification. So there's 22. We scroll down to the next one, which is preparer. This is jewelry preparer. Jewelry preparer is an alternate title for preparer. And there are 2, just 2, because it turns out the 5-digit NAICS codes 339910 is a very small occupation. They don't make a lot of jewelry and silverware manufacturing in America. It's just not done. The cost of labor is too high. And what I want you to realize is 339910 is a subset of 339900. When you add a non-zero digit, it's a subset. 33990 is an industry group of miscellaneous manufacturing, other miscellaneous manufacturing, and 339910 is a specific industry. In Canada and Mexico, they stop at 5 digits. The United States always has to have more detail, more complexity. And so we actually have a 6-digit NAICS code that we use in the US, but not in this one. So that's actually a subset. So actually we're still at 22. We're not at 24, we're at 22 because it's a subset. And then you get down to the final assembler, and we're at 339,100. Again, an industry group, not a specific industry. And it says there are 71 jobs. 71 jobs. So we're at 93. Reasonably, we're at 93. A vocational expert that says that there are more jobs than that is they're just making it up. They are just making it up. So I know that because I have a long-standing relationship with the literature, and so let's look at county business patterns because uh, because we want to. So if we scroll down, this is the 2, 3, and 4-digit industry codes, and we scroll down to 339. 31 to 33 is all of manufacturing. It's a big group, a lot of different codes in there. And we see that other miscellaneous medical equipment manufacturing is 308,000 jobs, and other miscellaneous manufacturing, which are the other two occupations, is 249,000 jobs. But that's 550,000 jobs in every single occupation. It isn't just one occupation, it's just every occupation. And so we scroll down and we get into the 3-digit, 3 and 4-digit manufacturing, 3, 4, 5-digit manufacturing codes, and we get down to 3391. And that is medical equipment and supplies manufacturing. And this is where Kevin is able to demonstrate that final assembler, there's a parentheses in the DOT code, says optical goods. You make optical goods in the ophthalmic goods manufacturing industry, 339115. Again, this is a 6-digit code, and it shows that there are 23,391 jobs right in the middle of your screen in every single occupation within that group. Now convince me, persuade me, tell me how it is that there could possibly be 39,425 people putting eyeglasses together in an industry that is made up of 23,391 jobs. It's nonsense. Which is more probative? Which is more reliable? The Job Browser Pro estimate, which uses it actually uses the wrong industry code because Job Browser Pro doesn't get down to the 5 and 6-digit NAICS codes, except with jewelry preparer and maybe one or two others, but it doesn't. It stops at 4, and it tries to universally use 4-digit NAICS codes because otherwise they start double counting jobs between different occupations. But even if it's a medical equipment supplies manufacturing, we still only get 71. And so the number is actually probably going to be far less than 71. I know that some of you will be surprised to find out that I've actually counted the number of production workers all that work according to the DOT, in the optical goods industry. It turns out to be 20. And so it's a very, very small number, very small number. And then 3399, which is our other manufacturing industries. Here we have 3399, other miscellaneous, 249,000. We see that jewelry and silverware manufacturing is in fact a subset of other miscellaneous manufacturing. But that's all jobs, all occupations in the entire industry. So county business patterns is listed. It is listed, and you have to be able to use county business patterns when it is to your benefit. Under the old paradigm of 004P, I often advocated that the industry as a necessary component was actually had to be consistent with that. Now that we're in a different era, we're going to have different problems, but we're still going to have to use that information. One of the other things that we see in our industry. Anybody still using the Occupational Employment Quarterly? Are you seeing that in your cases? Yeah, you are. I know you are. The Occupational Employment Quarterly says that there are 30,000 jobs, sedentary, unskilled jobs, and that's in 52 different DOT codes that are sedentary and unskilled. But if you actually look at their specific occupational employment unskilled quarterly, you see that jewelry preparer is only 128 jobs, and only 89.9% of those are full-time. And final assembler is only 75 jobs, and again, 90% of them are unskilled. And fishing reel assembler is only 604 jobs. Again, 90% of them are unskilled. So even the crazy U.S. publishing data that we do have doesn't support this vocational expert's testimony, which tells me that the vocational expert in this case violated the BSTIC rule. The BSTIC rule is your testimony using a widely recognized methodology? Is this something that other people are doing, or is this process of wild guess yours and yours alone? Would anybody else agree with you that there are 80,000 sedentary unskilled jobs? And Powley opens the door. We can now use every tool on our belt if you present it to the ALJ. The old paradigm of understanding under White and the cases following White and the unpublished cases following White wanted to require replication. You needed to nail down the vocational expert on their methodology so that you could replicate it. And the typical testimony in my experience is I use the BLS, the Bureau of Labor Statistics. I use SkillTrend. I use the Occupational Employment Quarterly. And I consider the county business patterns, and I consider the census reports, and I consider this, that, and the other thing. And well, how do you actually do it? Well, I put it in my mind, and I consider everything, and I come up with a number based upon my internal black box synthesis. The internal black box synthesis is non-replicable. You cannot replicate within 10% of Job Browser Pro because they use a black box that includes county business patterns. It says that they use the OEWS, but they're also using county business patterns. Some of the reports actually say they're using county business patterns, but how they're using county business patterns and how they're marrying SOC codes to census codes is opaque. And it's opaque because Jeff Truthen doesn't want you to replicate his methodology and put him out of business. So there's that. And so here is the 519199. I just printed out. This is an ONET report, the ONET crosswalk. And this is a list of unskilled sedentary production workers, all other. And if we scroll down, we see that there are 1,590. Those of you that are familiar with the Occupational Employment Quarterly will note that they report 1,589. And U.S. Publishing is actually correct on that because there's a duplicate. They changed DOT code numbers between 1991 and 1996 for one occupation in this group. And so they're actually only 1,589. But the ONET crosswalk lists all 1,590. Job Browser Pro reports 1,522 because they took it upon themselves to transfer 68 DOT codes to food workers, all other. The Department of Labor didn't. Jeff Truthen did. And so whether that's reliable is probably not. So this report says that there are 96 sedentary production workers, all other. 2 are SVP1 and 50 are SVP2. So if there are 240,000 production workers, all other, where's your confidence that there are actually 80,000 in these 3 DOT codes? It's just nonsense. It's not trustworthy. It's not reliable. It's not believable. And you have to expose the underpinnings of the job numbers in order to win your case. The vocational experts, I believe that people are motivated by their own self-interest. And if you don't believe that, please tell me what does motivate people. But I believe that people are motivated by their own self-interest. So what is the motivation of a vocational expert? Is it to get it right? Is it to make sure that people that really can't work be found disabled by testifying accordingly? Or are they more interested in keeping their job? Are they more interested in placating the ALJ? A good friend of mine became an ALJ 25, 30 years ago now. And he told me that we used to talk about Swenson v. Heckler. We would love to talk Swenson. It was one of our kumbaya moments. And he said, when I take the bench, I'm going to really give these vocational experts the what for. And he became an ALJ, and he confided in me in a private conversation that it's actually far more subtle than you think. It's the tone of voice, it's the inflection, it's the pitch going up, it's the, oh, you don't think there's any jobs, do you? And you just get what you want as the administrative law judge. And it's actually not nuanced at all. It's actually blunt. It doesn't show up necessarily on a paper transcript, but it shows up in a recording. And unfortunately, the reviewing courts don't get the inflections. And they only see the beta errors. They never see the alpha errors. They don't see the potentially erroneous grant of benefits. They only see the potentially erroneous denial of benefits. And so they get a jaundiced view of what's going on. So there are 52 sedentary unskilled DOT codes. For those of you that are DOT literate, you'll remember that there are 137 unskilled sedentary DOT codes. And when I say unskilled, I actually mean SVP 1 and 2. I don't mean unskilled as defined in 404-1568 paragraph A. Unskilled is actually defined as simple, little or no judgment, and 30 days or less. That's a different subject for a different day. But so Job Browser Pro doesn't support it. The SOOC doesn't support the vocational expert's testimony. The OEQ does not support the vocational expert's testimony. And so what does support the expert's testimony? Does Occu collect? Does the SOC support the vocational expert's testimony? So we take a look at that, and we see that there are 270 in OEWS, and OEWS does not include part-time work. I mean, it does include part-time work. It does not include self-employment. The Occupational Outlook Handbook includes self-employment. So this is occupational employment and wage statistics. And we start with 277,000 jobs. It turns out that there are only 26.4% of the jobs are actually unskilled. So that leaves 73,000 jobs. So if you're going to tell me that the 80,000 jobs are sedentary and unskilled, I know that your testimony has no bearing with, it's not consistent with the published data from the Department of Labor. And so one of the questions I frequently ask is, who's better at estimating jobs and job requirements? You with your local experience, or the Bureau of Labor Statistics with their economists and statisticians and their wide-ranging data collection processes? Who's better at it, you or the Department of Labor, the Bureau of Labor Statistics? Some vocational experts will actually tell you that they're better at it, but they're actually crazy. So a little more than a quarter of the jobs are unskilled. How many are sedentary? Less than 0.5%. John Metzger and I had the same vocational expert a year or so ago, and she was intentionally, in 2 different hearings, misreading the 0.5% as 5% to inflate the numbers. Just completely irresponsible. Just lying. What motivates her to to be caught transposing 0.5% as 5%, and in my hearing, and then 2 weeks later in John's hearing, do the same thing again. She's incorrigible, absolutely incorrigible. And if you believe that these vocational experts are neutral and unbiased, I believe they are neutral and unbiased, but they're also acting in their own self-interest because they are, in fact, human beings. So according to just a straight ORS analysis, this occupational group is less than 366 jobs. The less than 0.5% means it's a statistical outlier. We don't really have a good estimate. It could be zero. It might be 0.49%, but it's clearly less than 0.5%. So there's no rhyme or reason to the vocational expert's testimony in this case. But what we do know is that if you present your testimony to the administrative law, your evidence to the administrative law judge, the ALJ must consider your evidence. 404-1566D says that the commissioner will, and according to Professor Garner, will is the future mandatory requirement. It is the same as shall. And he prefers will as the better, more descriptive word, but the commissioner will take administrative notice of reliable government and private data. And so Judge Callahan has now laid 404-1566D on the lap of the commissioner. 24.3p says that the ALJ must consider all of the relevant data, which would include the data that you submit. And so you have a vocational expert that testifies to job numbers. You have to go after them. You have to present whatever evidence is helpful to your client, whether it's Job Browser Pro or the SOOC. I can't imagine a circumstance where the OEQ is ever reliable. The ORS, you have to go after them. You have to show that these job numbers just don't exist in significant numbers. In the Ninth Circuit, one of my most important losses, and I say that with humility, most important loss was in fact Gutierrez versus Commissioner, where the Ninth Circuit said 25,000 jobs is a close call. And so the cases from the Ninth Circuit have put the number up to about 18,500. Was not presumptively a significant number. That was little. There are a bunch of district court cases going every which way. Some saying that 18,000, 19,000, 20,000 is enough, but if 25,000 is a close call, and we take 20% off the top, and we're down to 20,000, 20%. If I took 20% off your fee, would you think that's close enough for government work? I don't think so. And when these vocational experts are testifying, they're not taking 20% off your fee. They're taking 100% off your fee. And more importantly, they're taking away your client's ability to survive. This is a beneficent statute. It is there to help people. It is a safety net. And we are duty bound by our own self-interest, in addition to being interested in our client's welfare. We are if I just acted on my own self-interest, I would go after these vocational experts. And Russell hasn't been practicing that long, but he's had enough time and enough experience with some of these judges that he knows what those judges think of his father. He's heard it from them. He's been accused of being a chip off the old block.
That's true, I have.
And it was intended as a compliment. Russell doesn't like being compared to his father very much, but sometimes it actually sits well with him. You will not lose friends on the bench by being aggressive and doing your job with vocational experts. You will win respect. You will win respect. And you can do this, but in order to do it, you need to have SkillTran on your desktop. You need to have SkillTran on your desktop. And Eric Slepian says while the better practice is to present vocational experts to the ALJ, it disappeared on me. The courts will accept arguments of evidence presented to the AC, and the AC did not exhibit the evidence. You can submit to the AC, but I think you're now in the replication problem. Because the question the appeals council asks is, did the ALJ have a substantial evidentiary basis to make their decision? And the evidence before the ALJ was this person can do a lot of jobs. And so in order to destroy the value of the vocational expert's testimony before the appeals council, you have to show that the vocational expert's testimony is not reliable. And so now you're not talking about a preponderance of the evidence standard. You're talking about more than a mere scintilla, enough that would satisfy a reasonable mind is the standard. And so I think you can get you can submit evidence to the appeals council, and if they exhibit it or they put it in the CAR, the certified administrative record, above the line, above the 1A, between the ALJ decision and the transcript, in that box there, you can, it is there, and the appeals council should have said something in the denial of review. It's not a decision. Don't call it a decision. It's an action. It says we considered your post evidence and we don't think it changes the ALJ decision. But if Job Browser Pro says that there are 30,000 escort vehicle drivers, and you submit evidence to show that the escort vehicle drivers actually sit 8 out of 8 hours, but the vocational expert presumptively under Terry v. Saul answered the question assuming 6 hours, and you didn't go after the vocational expert, and heaven help you. You have to ask that question. Where is it in the DOT that these vocational experts are that escort vehicle drivers are sitting only 6 hours, not more than 6 hours in an 8-hour day? The owner of Workscape told Russell in a hearing recently that he doesn't include the standing and walking as part of his hypothetical handler that spits out SOC codes, because if it's light, it already includes 6 hours of standing and walking. And if you've read the ORS Handbook of Methods, I have. If you've read the DOT Appendix C, I have. If you've read 404.1567 for the specification of exertional levels, you should have. Tell me where that says 6 hours in any one of those three. It's not there. The only place that it is there is in 8310. And 8310, I wasn't practicing law in 1983, but even if I had been, I would have not had the chance to point out to the Social Security Administration that the DOT and the regulations don't say anything about 6 hours. You're making that up. And Terry v. Saul actually punted the question of whether 8310 was reliable because, well, we just assume, we know that the ALJ, it's been around for 40 years, and the ALJs and the vocational experts, they all assume that medium includes 6 hours of standing and walking, despite the fact that the ALJ in that case actually said 6 hours of standing and 6 hours of walking. So clearly that ALJ did not assume that medium included 6 hours of standing and walking. He thought that it was 6 hours of sitting, standing, and 6 hours of walking. So you could be on your feet all day long, which is actually what medium work requires, being on your feet all day long. But that's not what the the state agency found. That's not what the CE found. That's just what the ALJ said.
Hey, you.
Nonsense. Yes.
Something.
Did you have a question, Belinda? Or you?
No, I think she was answering a
Okay.
call.
Actually, can you hear me?
I can. Who is this?
Yes. Yes. Hi, this is Brian Wilmer, longtime vocational expert. Just wanted to interject something since you brought it up. I wasn't going to say anything all day, but since you brought it up, escort vehicle driver is never a job I would offer. Do you hear it as a sedentary SVP2 job in hearings?
With some regularity, some vocational
Okay.
experts like you will toss it out because it's either
Well,
late.
Well,
Or
not some
skill.
vocational experts like me, because I would never offer it as a sedentary job, because my understanding of that job is that was misclassified in the
Mhm.
DOT years ago. So I would say that any job that involves driving is never sedentary. I mean, it's always at least light because of foot controls. So I appreciated what you said. And again, it wasn't my intention to interject, but I would argue that that's not a sedentary job in and of itself, and I'll stop there. But
Yeah, let me throw one other thing out to you, Brian. There's constant hand pressure on the steering wheel, so it's a constant exertion of negligible force. Doesn't that also make it light?
Well, maybe, but I mean, almost all driving jobs are medium. So, even setting that aside, though, I'm simply saying that I think, again, I've been told this, and I've been doing this a long time, 30 years as a VE. I started young. I was used to be one of the young guys, and I'm one of the old guys. But I've also done recent training with other programs around the country, so I'm still very active. And I'm not disagreeing with what you said, but I'm just saying that simply the foot controls make that not a sedentary job, but a light job. Everything else aside. So I'll
And,
stop there.
and SkillTrend actually supports what Brian just said. If you Google SkillTrend escort vehicle driver, it'll take you to his paper, to SkillTrend's paper that actually says exactly what Brian just said, which is that the exertion of, you're going to be putting at least 20 pounds of force on a steering wheel, on a brake pedal in an emergency situation. And that is, in fact, light work. Russell had a hearing with Dr. Hatakeyama in Orange, and the good doctor said that you never put more than 10 pounds of force on the brake, which is silly.
Nonsense.
So, yeah. So, and some Brian M, not Brian W, but Brian M said that he saw it a week ago from a VE. So, there are some people out there that reasonably and logically eliminate a large swath of jobs because they're not simple. They do require judgment. I've had vocational experts tell me that security guard is an unskilled job. And even if you're just a warm breathing body, being a security guard requires judgment. And I would argue, and I have argued, that the presence of significant judgment makes it it doesn't meet the 404-1568A definition of unskilled work because of the presence of judgment. It's an elemental test. Most of you that are on the call went to law school. You're familiar with elements. It's simple. It's no judgment, little or no judgment, and the conjunctive and 30 days or less. Yeah. Are there any other questions? Anybody else have any other questions they want to bring up?
Paulo Ortiz asks, would you suggest this be done during the hearing and as part of post-hearing?
At least as part of post-hearing, but I think you are obligated under 24.3p, even though we're not bound by 24.3p. We are in fact bound by 24.3p. You need to bring it up. Is your testimony consistent with the occupational requirement survey? Counsel, the vocational expert did not testify to using the occupational requirement survey. Okay. You gave numbers. If they gave numbers based on a SOC code, they have to be using some version of the of the ORS. You can't get there. If they're using Bureau of Labor Statistics data, that includes the ORS. So you need to do something during the hearing.
Larry,
You need to warn people that it's coming.
yep, I had another question, if you don't mind me jumping in. So under Pauly, I noticed that the car firm submitted what appeared to be 90 pages of records to rebut vocational consultant testimony. If I'm in a situation where I want to do those type of submissions post-hearing, uh, and I gather the reports through Occu Collect or Job Browser Pro, I don't get anywhere near 90 pages. I probably come somewhere closer to 10 to 12 pages. Are those reports, I know you don't have a crystal ball, but would that be sufficient, or is that just one step in this process for me to argue on behalf of my client, and what else would I need?
Well, if you present the Job Browser Pro reports, and the Job Browser Pro reports is for those three occupations, including all of the footnotes and explanatory citation of data sources, that's 7 pages. If you submit an OccuCollect an ORS report, that's going to be 18, 19, 20 pages. If you do that for 3 occupations, that's 60. So it's not hard to get up there if you present all of the data and then cite it. In the case of Rashidi versus O'Malley, or maybe it was Kijikazi still, it was a Ninth Circuit case. The court was critical of the several hundred pages of data. Apparently, Judge Callahan would be impressed with that. That case, actually, I lost that case at the Ninth Circuit, unpublished opinion. I went to the Supreme Court, and the Solicitor General and I worked out a deal where it went back, and my client was eventually awarded benefits. But in general, my personal philosophy, Eric, is that less is more. As Descartes and Mark Twain said, I apologize for the length of my letter. If I'd had more time, it would have been shorter. So I think that if you can nail it in 10 pages or 15 pages, nail it in 15 pages. You don't need to go on and on. So let's see. Michael Stern says just use foot controls. Yeah, that's right. Yeah, and one of the other things that the other basic question is, how do you extrapolate your local experience to the national economy? It really isn't. It really is critical to ask that question. How do you extrapolate your local experience to the national economy? And Justice Gorsuch, in his dissent, says that for all we know, these numbers could have been pulled out of a hat. And I thought that was a very delicate way of Justice Gorsuch of characterizing it, pulling it out of the hat. If you look at that testimony, one of the jobs is, in fact, a companion to final assembler. One of them is nut sorter, which is on the emergency message list. So, but for some careful submission of post-hearing evidence to show that the vocational expert's testimony was garbage, Justice Gorsuch might have been able to pull a couple more people over to his side of the aisle, and Beastick goes the other way. It just does. Ford, in the Ninth Circuit, the vocational expert testified to 100,000 office helper jobs. Most of those jobs, if you look compare the OEWS to employment projections, most of the jobs are in fact self-employment, and they're self-employed couriers and messengers. They're running a messenger service out of their house. We have to do a better job. We just have to do a better job. Is there a significant evidence in Job Browser Pro that merchandise and markers exist at the light in significant numbers, and is this consistent with the clients of mine who worked in these jobs? Job Browser Pro uses an equal distribution at the SOC Standard Occupational Classification, NAICS, North American Industry Classification System, intersection. And if you run an ORS report, you'll see that most of those jobs are in fact medium. The definition of light in the ORS is 25 pounds, and darn few of them are on their feet 6 hours a day or less. You have to use all the tools on your belt. Job Browser Pro does claim 120,000 jobs as a marker, but it's soft. You have to go after it. I'm friends with Jeff Truth, and he and I have had some great conversations over the years. I've spent a lot of time at NOSCR conferences with him, talking about these issues. But that doesn't mean that my friendship with Jeff has nothing to do with the fact that I think that Job Browser Pro, in many cases, overstates the number of jobs. I would never accuse him of understating, but I would accuse him of overstating, because I have a job to do. Yeah, we're all on the same page. I don't get GV. Yeah, there's the vocational experts saying that they've reduced the 25 pounds. In my experience, these jobs only require 25 pounds. What is a statistically relevant number of jobs? If there are 100,000 jobs in the national economy, at what point does a statistician say that this number is statistically relevant? Is it 100? Is it 1,000? Is it 50? Is it 75? I bet it's not 3 or 4. And if you have a vocational expert that did 3 or 4 job analyses, they've seen the occupation 3 or 4 times. That is not a statistically relevant number. Not relevant. It doesn't lead to a relevant statistical analysis. How do you extrapolate from an experience of 3? Yeah, we're all crazy. Any other questions?
Jennifer, yeah.
Go ahead.
Jennifer Bogart asked, is the probative and significant issue part of the statute or SSR, or is it Ninth Circuit case law?
Significant and probative is part of just jurisprudence. It's just a jurisprudential rule. And that actually reminds me, this is something that Russell and I were talking about. We're all familiar with, because we're actually competent adults, the story of Brown versus Board of Education, where the Supreme Court overturned Plessy versus Ferguson. But it wasn't just, we just don't go from Plessy to Brown in one step. There were a number of cases in between where the courts were saying, well, Plessy is the law of the land, but in this case, it was separate and unequal. In this case, it was separate but unequal. And eventually, the court gets to the point where it says, we're done. We are done. And for me, I've been litigating these vocational issues for, Brian, our vocational expert friend, said he's been doing this for 30 years. I'm going to double down on him. I've been doing this for 40 years, cross-examining vocational experts. This is our Brown versus Board of Education moment, where we now get to stand on equal footing with the vocational expert, because our lack of vocational expertise is a factor, but not dispositive. It is not the straw that breaks the camel's back. This levels the playing field, and now we get to fight fair. We get to fight fire with fire. We get to we get to fight vocational experts who won't turn over their stuff because B6 says they don't have to, and we get to turn over our stuff and say, this is the report that wins the case. And Eric, who was running the meeting today, has added to each and every Job Browser Pro report, Occu Collect report, the statement that this data is a true and correct replication of the data from the sources cited. So if you're citing a county business patterns report, the citation is to the census government, the Census Bureau, census.gov data, datasets 2023 econ, CBP 2023. We're citing our sources, and anybody can go back there. It's actually quite difficult to replicate county business patterns to get a report, a national number report for a single or group of NAICS codes. It's time consuming. And if you're using Workscape, you're wasting your money. They don't include all the data. They've cherry picked their own data. Other than skill trend, how do we argue that a percentage of a SOC code is occupied by a DOT specific occupation? Use the, James, I suggest you use the ORS. Use the ORS. We have that data. And if job for small products assembler 1, small products assembler 2, and several other DOT codes, they're all, one of them is medium, the rest of them are light. How many of the jobs within production workers are actually light? 11.1%. 11.1%. And he has 80% of them are light. And these are in temporary help services. And temporary help services, according to the Census Bureau, is temporary help. It's not temp to hire, it's temporary help. There's a different industry code for temp to hire. And so when Skill Trend assigns 80% of those jobs, and that's over half of the jobs that are cited for small products assembler 1 and 2, it's soft. You can attack that, but you have to pay attention to the industry codes that are cited in your Job Browser Pro report. You cannot just go off on the bottom line number. You have to read the box above it and pay attention to the industries and ask yourself, do small product assemblers assembling small products such as carburetors work in the animal food manufacturing industry? The common sense answer is no. It's no. And Job Browser Pro Skill Trend is not there to defend their industry selections. It's up to the vocational expert to defend the industry selections and why they included those jobs in their estimate. So, anybody else have any other great questions? What is the best way to approach once you get a VE, just to refer to experience? How does your, so the question is, how, if they rely on their experience, how do you get there? What is it about your experience that informs you of the national economy? Well, I've been doing this for 40 years. In what area of the country have you been working? Well, I work in Southern California. I work in Minnesota. I work in Southwest Texas. How do you extrapolate your experience to the national economy? Given the fact that the Bureau of Labor Statistics has done a nationwide survey of the job, of the occupation, of the occupational group, on what basis do you disagree with the BLS? Well, I think they're wrong. That and $6 now will get you a cup of coffee at Starbucks. You have to use the ORS, and the 25 pounds. SSA is going to have to redefine light work. They're just going to have to. They're going to have to define it as 25 pounds because labor is not going to redo the ORS now. They went from 20 pounds in the 2017, 2018, 2016, that the data set that culminated in the 2018 data set. And then when we get to the 2023 data set that has all those other preliminary sets in between, the definition changes to 25 pounds. It resolves the problem of how about occasional lifting of 22 pounds? Is that light or is that medium? It's medium, but now it's light.
I just want to expand on that, just to be real clear, because what will happen is I'll get to the ORS data, I'll be asking them, okay, you're inconsistent with light, you're inconsistent with unskilled, and all I'll get back is just, oh, my experience. And they can't give me anything else, so I can attack all 3 jobs with every single ORS data field. At what point is it kind of like I just need to stop spinning my wheels and wasting the judge's time, as opposed to, do I need to go through every single inconsistency, or where should I just kind of let them leave it hanging with experience?
Is all of your testimony based on your experience and rejecting the ORS data set? That's the question. One question. All of your testimony. Lump it all into one box. And we don't have to exhaust now. We don't have to give the vocational expert a loaded pistol and play Russian roulette. We don't have to do that. We can just leave it there. So your testimony is based on your experience and you reject the occupational requirement survey. Did I understand you correctly? Yes. Great. Thank you. We'll move on now. We'll move on. If you don't have access to skill training, you need to sign up with ACRD. Sign up with ACRD. It's actually cheaper than it used to be for buying multiple licenses from SkillTran. But sign up with ACRD and get your skill training. It's part of the ACRD membership package. You get Job Browser Pro, you get Oasis, you get their other product.
So it sounds like in regards to Laura Hart's question, it sounds like your answer is you have to have it.
I loathe the Occupational Employment Quarterly. Loathe it. I think it's garbage. I have a copy of it. I have a copy of the fourth quarter of 2025 on my hard drive, and I use it when I need to. I think the SOOK is marginally useful. I would never advocate for it, other than for advocating that the vocational expert's testimony is not supported by any of the three primary methodologies. The primary methodologies are Job Browser Pro, an ORS-based, OEWS-based analysis that is reflected in 24.3P, and the Occupational Employment Quarterly. And if your client has an orthopedic problem, but you don't want to talk about orthopedics, you're going to lose your case. And if the doctor says bone-on-bone degenerative arthritis in the right knee, they could stand and walk for 6 hours in an 8-hour day or 4 hours in an 8-hour day. You pulled John Kwok, MD, out of the hat. You need to be able to go after him. Why would anyone have a total knee replacement when they can stand and walk for 4 hours in an 8-hour day? It's because they can't. It's ridiculous. So you have to go after them. The audio and video of this presentation will be available on YouTube. Eric will have it up later today. Thank you, Joseph, for your question. Any other questions?
I have a question. So
One
a couple of the common bases for rejecting rebuttal evidence cited by ALJs and by the commissioner in district court and circuit court proceedings is the lack of expertise, and they rely on Kilpatrick and Wishman. What does Powley do on that regard?
It takes the plunger and pushes it all the way down until it explodes. That is no longer a basis for rejecting post-hearing submissions or pre-hearing submissions or any other kind of submissions. It is a factor. So if it's a tiebreaker, the vocational expert's testimony is in equipoise, equal position to the data. They differ only slightly. The data suggests 19,000 jobs and the vocational experts suggest 26,000 jobs. Maybe in that case, you could use the lack of expertise, but our pitch is not that I know what I'm talking about. The pitch is that the data knows what it's talking about. And the commissioner has promised us an administrative notice. I had a judge recently ask me, he said, "Are you a vocational expert?" And I said, "Well, that depends on who you ask, I guess, because I'm regarded by members of the bar to be an expert. I'm actually, if you look at the methodology pages for SkillTran, I am personally listed as a co-presenter with Jeff Truthen at several conferences, and I'm actually listed as an important source of peer review. So Jeff considers me to be peer review. So I think I am an expert. Well, are you gonna be testifying today? He's like, "No, because I'm not foolish. I can't testify if I'm going to be the attorney because I can't argue my own veracity, but I can ask you to take administrative notice, which I intend to do and I have already done. So you too can swing from the trapeze.
And one more question. So Powley is there anything that you get from Powley as uh telling us what we need to do as representatives in when we submit our rebuttal evidence, anything that we need to either authenticate or identify when in those submissions?
Yeah. I ran these reports off the internet today. I downloaded from Occu, and Occu swears that their data is true and correct. And I ran these reports off of SkillTrend today, and SkillTrend says that their data follows their methodology that's published. And this is a true and correct copy of the Occupational Employment Quarterly, or the specific Occupational Employment Quarterly for the sedentary occupations. In civil litigation, you don't just drop medical records on on a jury trial. You have to have somebody come in and authenticate it, that these are, you have to have somebody swear that these are business records that were accumulated in the ordinary course of business, and they're the true and correct copies of the papers that are in the file. You have to establish the exception to the hearsay rule. And so we can have hearsay, but we need to assure the ALJ, they know, they have access to Job Browser Pro, but we need to assure the court that we're not making it up. I've actually seen cases in the Ninth Circuit Court of Appeals where somebody had redacted harmful information from exhibits that were in the district court files, and the Ninth Circuit wanted to know why. So we need to keep our hands clean by swearing with our license on the line that we're not making this up. Yeah. John Metzger, do you have anything to add?
Hey, Larry. Thanks for asking. Yeah, I wanted to point out one of my favorite questions. Once we have the VE under oath, we have a real unique opportunity to get them. It's our one and only opportunity to really ask whatever questions we want the answers to. Most people pass up on that opportunity, and I spend a lot of time in my practice thinking about, God, what is the real question that I want answered in this case? So one of my favorite questions when a VE says, gives an answer that makes no sense. They say, I have 25 years of experience making false statements in front of ALJ hearings. And that's what I base my answer up on. And you can ask the same questions about their methodology several times. And you can, after getting a couple of nonsense answers or word salad answers, you can just say, I didn't understand any of those answers. So let's try this. Please state all facts upon which you base the job number estimates that you testified to today. They will never, ever, ever be able to answer that question. And that's the question you really want answered. You want the entire factual basis for their job number estimates. And if you ask that one question, again, it's please state all facts upon which you base the job number estimates that you testified today. They will never, ever do that. And you will guarantee yourself an automatic appeal just by throwing in that one thing.
Good advice, John. Thank you very much.
You're welcome, Larry.
Yeah. Anybody else have any questions? If not, I'm going to pull the plug and get back to work.
I want to make a comment on what you said about authenticating our documents. Our calculator reports, I know it's on our calculator reports for OccuCollect. I don't know if it's on the other reports, but we've actually included the language that Lawrence talked about. This report is a true and accurate restatement of the sources listed below and a list of sources. And we've also included who the report was generated by and the date that it was generated on. And
the
so
user generating and the date generating are only on the report on the calculator right now.
Okay.
That'll be rolled out to all of the other reports going forward after this meeting. So if you have not already, make sure you go to the profile section of Occu Collect. Make sure that your first name and last name are correct in there. So that way, when you generate a report, it's going to generate with your name properly.
Right. Thomas Duncan has just asked, how do you deal with a vocational expert who says that all non-exertional limitations are accounted for by JBP and the SCO? And so they don't need to use the ORS. If you go to SkillTran methodology, or how they get their job numbers, they actually spell it out what their process is. There is one input in Job Browser Pro or SkillTran Oasis. There's one input. It's the DOT code. And then there's a toggle for part-time and full-time. And there's a toggle for state and locality, region. But we don't care about that. We don't care about region anymore. We just care about national job numbers. Ever since Gutierrez versus Commissioner again, my loss. Where can I input into Job Browser Pro a limitation in standing and walking, or a limitation in reaching, or a limitation in occasional contact with others? There is no input for that. There's no input for it in the Occupational Employment Quarterly. There's no input in it. They're just identifying job numbers for a DOT code that happens to have those characteristics. But there's no limiting factor. It's all done with equal distribution. And so tell me how to tell Job Browser Pro how to do that. In Oasis on the web, you can search by worker traits, and you can select physical and environmental and strength limitations, GED limitations, SVP limitations, aptitude limitations. You can select those, but it's not selecting job numbers. The job numbers are still using the same process that SkillTran says it uses. Matching DOT codes into SOC codes intersecting with NAICS codes. How many DOT codes are in that intersection? Divide the number of jobs at that intersection by the number of DOT codes, and that's the number of jobs that are assigned to that DOT code. It has 0.0 to do with the physical, non-exertional, environmental, mental, cognitive, or other limitations that you have. It's just number of DOT codes, number of jobs divided by the number of DOT codes. Yeah. Michael has suggested that people pay attention to the data, people, things codes, codes 4, 5, and 6. He also says the fifth digit code is the lowest for people involvement, and it correlates well to no occasional talking. No, that's actually not right, Michael. It means that there is no requirement for talking to people outside of your job. It's talking to the public, occasional talking to the public, but it doesn't have anything to do with following instructions and responding appropriately to criticism from supervisors. If you Google POMS mental limitations, you get to a POMS provision that says clearly and unequivocally that the critical requirements of unskilled work include completing a normal workday or work week without interruptions that are unreasonable. These requirements are strict. Accepting and responding appropriately to criticism from supervisors, asking simple questions or requesting assistance. You need to be able to ask questions. You need to get along with coworkers and peers without unduly distracting them. These are communicative limitations. And paragraph G of POMS 25020.010 actually says very clearly, let me go ahead and share my screen. There it is, share. So we're dealing with POMS 25020.010. We go down to paragraph B3, and we have this list of the mental abilities that are critical to performing unskilled work. And so I actually ask these questions. Is working in coordination with or proximity to others without being unduly distracted by them critical to performing unskilled work? And if they say no, then their testimony is inconsistent with agency policy. I ask them, is it critical to be able to respond appropriately to changes in a routine work setting? No, it's not. Well, then your testimony is inconsistent with the agency policy. Is getting along with coworkers or peers without unduly distracting them or exhibiting behavioral experience.
Settlement. It's either, is there any way other than spending it down to have it
Cliff,
not?
can you mute your microphone, please?
Is getting along with coworkers or peers critical? Is working in coordination with others critical? Working in proximity to others critical? These are fair questions, and these are not my categories. These are the agency categories. Because if you look at 404.1545C, you'll see that the mental RFC has a such as list. It's not an exhaustive list. And this is the exhaustive list. POMS is the exhaustive list. So put POMS in your back pocket. Yeah. Yeah. Any other questions? You can unmute your mic and ask, or forever hold your peace. I want to thank everybody that's joined us today for this session. I really am excited about Powley. This really is. I've said publicly that this is the most important decision since in the Ninth Circuit since Zavalin. I think I understated that. I think this is the most important decision for Step 5 ever. Ever. We are no longer, we're unshackled. We can submit rebuttal evidence and have it taken seriously. We don't have to replicate what is unreplicable. We can vigorously represent our clients, and I want to commend you on taking the time to get familiar with this process and to be emboldened, because I believe that you can, in fact, do this. It just takes 3 or 4 times, and you'll be an expert. Russell's been practicing law for less than a year, and he's actually getting compliments from judges on his tenacity. Of course, the apple did not fall far from the tree. But I want to thank you all once again. Have a great day.
Oh, and just confirm the POMS number that you mentioned for mental abilities of unskilled work. Was that 25020.2010?
No, 0.010.
Oh, that's okay. All right. Thank you.
Yeah. I never, Mozelle, I never remember the number. I just Google POMS mental limitations.
Right.
And my first result is always this POMS provision, but it is 25020.010.
Great. Thank you.
Sure thing.
Thank you, everybody.
Thank you, Lawrence. Thank you, Russell. I really appreciate everyone joining us today. Have a great day. And if you haven't, please sign up for Occu Collect and let me know if you have any questions.